Hi, everybody. My name is Olivia Romanson, and I am your presiding judge for this year. And for this video, we are going to be going over objections, really just understanding some super basic objections or common ones that may appear in your trials. Now, please note that I will not be going over every single objection within the mock trial rules of evidence. However, if you have any questions about a specific rule that isn't covered in today's video, please feel free to reach out for me. And also just make sure that these mock trial rules of evidence are provided in your gap, or also just have a copy on you at all times and really just get familiar with those rule numbers. So without further ado, I'm going to share my screen with you guys. All right. Okay. Okay. Perfect. So going over objections. So first things first, really, how should we object? Only the attorney who is directing or crossing that witness can object. Meaning that if you are the attorney who is directing John, only you can object to any statements provided by the opposing counsel during cross-examination. Your co-counsel cannot do that. And what if you hear a question that you think is wrong based on the rule numbers, you're going to stand up and you're going to say, "Objection, Your Honor," under rule whatever, and you're going to explain your objection. It doesn't have to be this long-winded response, but especially if it's hearsay, please give an explanation on to why it is hearsay. Leading question, you don't need to give an explanation. It's a leading question. But make sure that you have rule numbers to go with it to really just boost your score and help your judge out. Also, be confident. You are standing up and you are objecting, and that is awesome. We encourage objections within our Oklahoma mock trial circuit. So be confident with it. It is okay if you are wrong, and it's going to be ultimately up to the judge's decision. Also, a really big thing that we've started to implement this year is to wait until you are called on by the judge for a rebuttal. So, say your opposing counsel objects to a question of yours. The judge, depending on their discretion, can look to you and ask for a rebuttal. But if they do not ask for a rebuttal and make a verdict without it, that is okay. It is up to the judge ultimately, and you don't want to appear disrespectful within their courtroom. So, big thing that we're going to be talking about is relevancy. So, let's first just go through our objections. So, Rule 401 is our definition of relevant evidence. Pretty much, the definition of relevant evidence is a pretty low bar because it's any evidence having any tendency to make the existence of a fact that is of consequence to the determination of the action made probable or less probable than it would be without the evidence. Basically saying, if you have a piece of evidence that is proving any factor within the case, it's pretty much going to be relevant. But what's really the question about it is, what is the evidence probative value? Any tendency, and probative value is any tendency to make fact more or less probable than it would be without evidence. Evidence is relevant if that's any tendency to make a fact more or less probable than it would be without. Very simple, very straightforward. Relevant evidence, it's a pretty low bar. So sometimes just objecting with the idea of relevance isn't going to be your best bet. So what I believe is going to be your best option is going to be Rule 403. And that's the exclusion of relevant evidence based on the grounds of prejudice, confusion, or waste time. And what this objection says in its plain text is, although relevant, evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice. So basically, to sum that up, it's saying that this piece of evidence, while it may be relevant, is more harmful than helpful. And by doing this, you're going to be able to get a lot more verdicts on your side. Because it could be something that of a witness's smoking problem, drinking problem. Now, while it is evidence, it's not necessarily relevant to prove that they stole something. Do you know what I mean? Because it creates bias for the jury. It mixes up issues. It wastes time. And so what you are going to say is objection, Your Honor. Under Rule 403, this question is irrelevant, confuses the issue, or is prejudice. The probative value of this evidence is substantially outweighed by its prejudicial effect. And this can be whether it's relevant, confuses the issues, or is prejudice. It's kind of like a three-pronged thing that this whole rule covers. But a big thing is be prepared to explain why is it prejudicial. Because you're saying that it's going to outweigh its positive effect. So explain why exactly that happens. And to really just help the judge come to your side. And a lot of it is going to be based on bias and stuff like that. And if this objection is raised against you, you will have the opportunity to explain how this piece of evidence actually shows what you need it to prove for like motive, means, and stuff like that. So I told you really quick and fast. So now we're moving on to this idea of speculation. So speculation is under Rule 602, lack of personal knowledge, which is a witness may not testify to a matter unless the witness has personal knowledge of the matter. Evidences prove personal knowledge may, but need not, consistent of the witness's own testimony. So basically, it is saying that a lay witness, which is someone who isn't necessarily an expert witness and only can testify to what they can observe and experience, cannot definitively state something that they do not know. So the objection that you're raising is under Rule 701. This witness could not rationally perceive that and therefore cannot testify. Now, Rule 701 is basically lays the background and the context to which a lay witness can testify to. And a lot of it is based on a rationally based perception of the witness and to helpfully to a clear understanding of the witness's testimony or the determinations of a fact and an issue. Now, that is a lot of words, but basically what its biggest meaning is that if you, the person watching this video, were asked in trial, what was the mental state of me, Olivia, as I was presenting this video? That is complete speculation, as that question is going to call for speculation. Because while you can rationally perceive that my voice is high or that I'm smiling and I'm not crying, you cannot for definitely state what it is I am thinking, as you are not in my mind in the same way that I am not in yours. So a big deal is asking of like what was mental state. That question is going to call for speculation. So a lay witness can see something, hear something, has access to some evidence, but can only make very limited inferences. It cannot guess, it cannot predict. Now, this is a little different if your witness is an expert, because they can make some inferences within their field of expertise. So with this idea of mental state, that witness, if they are an expert in childhood development and psychology, could make a better inference and have a broader way of topics that they can speculate about and predict about, as it is within their field of expertise. Now, if you have an expert in the field of psychology, they cannot make inferences in the field of police investigation. Even though they are still an expert, they are still confined to their specific area of expertise. So a good way to respond to this objection, if this objection is raised against you, is a couple of key responses. You can respond that this witness is qualified as an expert to make reasonable inferences based on the evidence reviewed. And that is if they are an expert witness, of course. Don't just say that for a witness that has not been entered. Or you can be like, Your Honor, the witness's response is based on personal observations, and kind of give a more of an explanation that this question isn't necessarily speculation. Or you can just rephrase your question or move on. With this example of mental state, if you were to be asked what was the mental state of Olivia as she was presenting, and that was to be objected to as it calls for speculation. As the attorney, you could be like, Your Honor, I can rephrase that question. And instead, you can ask the question, what did you see about Olivia's behavior while she was presenting? And that way we can testify to what we saw and what we perceived on a rationally based perception. Therefore, it is no longer speculation. All right. So basically, now we're going to go into a little bit more of the objections of the mode of the courtroom. So 611, Rule 611 has a lot of different subsections to it that has to do with the mode of and order of interrogation and presentation. So first is Rule 611A, control by court. So basically it says the court shall exercise reasonable control over the questioning of witnesses and presenting evidence so as to, 1, to make the questioning presentation effective for asserting the truth, 2, to avoid needless use of time, and 3, protect the witness from harassment and undue embarrassment. So when looking at this idea of subsection 2 of A, to avoid needless use of time. And that's basically is if your opposing counsel has re-asked the same question over and over and over again, and they keep getting the exact same answer, therefore you just raise the question or raise the objection that this question has been asked and answered. And you can cite rule number 611 to help get up some points for evaluation. Secondly, you can look at rule 611 when looking at badgering or the very argumentative presentation by the attorney to a witness. Because on section 3 of rule 611A, it says to protect a witness from harassment or undue embarrassment. Now, it is very careful you need to be careful in what you consider to necessarily be harassment. Just because an attorney may be speaking with a serious tone doesn't mean it is harassment. However, when they're saying questions of, you killed her, didn't you? Or why are you lying to me right now? And using very aggressive language, as well as maybe approaching your witness, yelling at your witness, immediately step in with this rule 611 section A, my witness is being battered, objection. Because as an attorney, it is your job to protect your witness from the opposing counsel, because the witness is up there on the stand all by themselves. They need just a little bit of protection, and that comes from you. So also you have rule 611 section C. Now we did a little bit skip over rule 611 section B, but that's basically just the scope of cross-examination, saying that anything that is brought up in direct or in cross-examination is not limited to the scope of direct examination. All that really says. Something we all pretty much understand. So I just moved on a little bit to section C, which is our leading questions. So this objection should only be raised during direct examinations, because only in direct are leading questions not allowed. They are perfectly allowed within cross-examination. And of course, a leading question is never just a yes or no question. So some examples of it is, did you graduate from Michigan? That's not a leading question, because I can answer that in yes or no. Do you know what I mean? Like if I'm like, no, I didn't, that's perfectly fine. Or yes, I did. And you graduated from Michigan, correct? That is a leading question, because it is now probing your witness to answer in a very specific way and provides the answer within the question. So of course, yes or no does not always mean leading question. And just a little side tip, is look out for leading questions during redirect. Because when usually on a redirect, you're thinking of some questions on the spot. However, you are still subject to leading question objections. And that is one of the biggest points that a lot of people do have leading questions. Or maybe their witness is struggling to recall an answer during direct examination. And you notice that they'll start asking a lot of leading questions to get out the answer that they want. Now, while that is good strategy to help probe the witness's memory, it is still within your right to object to leading questions as they are not allowed during direct examination in any capacity. All right, so again, Rule 611, our favorite rule, Section D has to do with scope. So as I talked about previously, there is no cross-examination is not limited to the scope of the direct examination. It's completely open door. However, on redirect and recross, the scope is going to get smaller. Basically meaning that in cross-examination, if I only talked about cats, this is the only thing I questioned about, and you decide to take a redirect and you bring up dogs, that is completely outside of the scope because you are now subjected to the things that I talked about in my first cross-examination. So if I only talked about cats, you can only talk about cats. And the same way that if you talked about cats in your redirect, that recross can only talk about cats as well. The scope gets smaller and smaller with the more redirects and recrosses. And whenever somebody steps outside of that scope during redirect, you bring up the objection of under Rule 611, Section D, this line of questioning is outside the scope of my cross. So be listening to the questions that happen during redirect and being like, did I ask about that in my cross? Because if you didn't, immediately raise this objection. All right, so now we're moving on past 611, and we're going to talk about some objections to an expert. So basically, Rule 702 is testimony by experts. And the bottom part of it says that a witness can qualify as an expert by knowledge, skill, experience, training, or education. So if your opposing counsel is trying to enter in their witness as an expert, and you do not believe that knowledge, skill, experience, training, or education has been properly proved, you can raise the objection of under Rule 702, the proper foundation has not been set for this witness to be entered in as an expert witness. And by doing this, you're just proving that there's a lack of foundation, really, and really showing off that you know your rule numbers to help you get more points with your evaluator. But do know that you only need one of those things to be considered an expert, because it says the word or education part, proving you either need knowledge, skill, experience, training, or education. Awesome. Okay, perfect. So that goes over a lot of our previous rules, talking about from relevancy to expert witnesses to scope and speculation. And now one of their biggest chunks of your rules of evidence is hearsay. So we're going to start going over that. Hearsay is going to be all your Rule 800s. So what exactly is hearsay? It's an out-of-court statement being offered for the truth of the matter asserted. So spoken statements would be considered out-of-court statements, written statements, generated statements, and it's basically these statements that weren't provided in court. And the reason that they are untrustworthy and that we have so many rules against them is because if I said out of court, John told me that you, the person watching this video, cheated on their ACT and that you somehow got all the answers and that's how you made a 36. And I said that outside of court. So by doing that, I can just say whatever I want to say. And I can come up with a lot of lies, like rumors. It's like a big game of telephone where the truth gets to get all mixed up and you're never really sure what's true. However, the opposite of that is an in-court statement. Any in-court statement that you may have is subject to cross-examination. So if I said that exact same thing with in court, saying that you cheated on an ACT, the opposing counsel can now question me about it and try to figure out how exactly I came to that conclusion. Is that conclusion even true? Is there a motive behind it? All the sorts of things that makes cross-examination so much fun to just prove some weaknesses and contradictions. So basically, if it's offered for the truth of the matter asserted, an example of this is that Todd is on the stand and says, Jimmy told me that he was in Ohio to meet John. Hearsay is offered to prove that Jimmy was in Ohio to meet John. That is the truth of the matter asserted. But what's not the truth of the matter asserted is that Jimmy could speak or understand English. That's not what I'm trying to prove. What I was trying to prove was that Jimmy was in Ohio to meet John. But what that doesn't mean is that every time you have hearsay, you just say, hey, that's not actually for the truth of the matter asserted. It was just to prove that she can speak English. No, that's just not going to fly. It's just for the sake of the example. So with that, just quick, the hearsay rule is being broken is Rule 802. Hearsay is not admissible, except as provided by these rules. So we're going to go over the exceptions as provided in Rule 803 and 804, but whenever there is an out-of-court statement that is provided for the truth of the matter asserted, you're going to bring up Rule 802. Susie told John she heard Jesse say he was going to kill Sarah, and John testifies this in court. That's my example. You see how John got it from Susie, got it from Jesse, who said that she was going to kill Sarah. You see that big chain of events? The he said, she said of it, that is what is considered hearsay. So within this case, there are some conversations. So there are exceptions to hearsay. And that's what we're going to start going over. So Rule 803 is if the declarant, aka the person who said it, is still available, whether they are in court, still alive, stuff like that. So 803.1 and 803.2 are very, very similar. Basically, 803.1 is present sense impression, a statement describing or explaining an event or condition made while or immediately after the declarant perceived it. So straight in the moment, really didn't have a lot to think about, and its statements made too quickly to offer time for reflection. In the same sense, that Rule 803.2 is excited utterance, a statement relating to a startling event or condition made while the declarant was under the stress of excitement that it caused. He bit me. You almost ran over me. You terrified us. All of those saying almost seconds after an event happened would be considered excited utterance and would be considered an exception to the hearsay rule. And if you're going to do that, you do need to prove in your line of questioning that it was directly after a pretty startling event for it to be considered excited utterance. 803.3 is then existing mental, emotional, or physical condition. So 803.1 is external events that you perceived. Present sense impression. You perceive it, it's external, it was right there, you kind of just said it without thinking. 803.3 is stuff that happened internally. Oh, my head hurts, I feel sick. And those are said as the declarant's then existing state of mind or emotionally, sensory, or physical condition. Basically meaning stuff that happened right to you in that moment, and it happened inside of you instead of something you perceived. 803.4, statements for the purpose of medical diagnosis or treatment. 803.5, recorded recollection. Whoa. I can totally talk today. But all of these are to say they're just statements that are then excluded from hearsay as they were provided then and there. 803.6 is records of regularly conducted activity. So basically, that is going to be your business record exception. So stuff that talks about a memorandum or really anything of the sort. It has business records, stuff that was considered that was conducted regularly. Goodness gracious. Um, and so the reason that you're going to be able to have to prove this and to have that exception already pulled up is that you got to ask, do you recognize this document? What is it? Was this document kept in a regular course of business? Was it regular practice to make these documents such as this one? So what isn't considered a regularly conducted activity is if on a January 15th, I wrote on a sticky note that everybody in this office is not going to be held liable for any losses or damages of the people who slept on the floor. That is not a regularly conducted activity, as I have never done that before January 15th. So that's not going to be put under this exception. But if every single day there was a record of receipts, of our taxes, of accounting, and you prove that this is something that you regularly keep care of and track of as a business, it is then considered under this exception. And they also, within this exception, have a definition for the term of business, which includes businesses, institutions, association, profession, occupation of calling of every kind, whether or not conducted for profit. So it also gives a definition of business that you can use as part of your explanation of this exception. Perfect. All right, 803.18 is learned treatises, works / references of expert witnesses. And basically, it's stuff that an expert witness relied on to get to their conclusion that they then testify to within direct examination. 803.21 is reputation as to character. And it's a reputation among a person's associates or in the community concerning the person's character. Basically, meaning of the character of a person in their community. And of course, 803.22, judgment of previous conviction. So if they had a previous trial that has like any lettering from it or their jury decision, verdicts, previous like jail times and stuff like that, that is not considered hearsay. Okay, so that is all if the declarant is available, and it is a lot. And there's a lot of exceptions that you should go through and figure out if they are applicable to your certain situation. But those are all if your declarant is alive. Rule 804 is if your declarant is unavailable. And it's defined as unavailable by not being there by ruling of the court. They refuse to testifies to a lack of memory on the subject, is dead, or is absent from the hearing. Sometimes within a stipulation, it will state that a witness was considered unavailable by the court. And basically, a lot of this has to do, what we have in our cases most often is our victims of murder, as they're unable to testify as they're no longer here. So with that, how are we able to navigate their conversations? So 804B is basically every exception to hearsay when the declarant is unavailable. So first, you have former testimony. If the declarant was in a previous trial and you have access to the deposition or to their transcript within the court, all of that is completely admissible. Statement under belief of impending death. So in the same sense that you have excited utterance when the declarant is available, you have statement under belief of impending death. In a prosecution for homicide or in civil action or proceeding, a statement made by declarant while believing that the declarant's death was imminent and concerning the cause or circumstances of what the declarant believed to be impending death. So you need to first prove with this exception is that the declarant did believe that their death was imminent and was going to very much happen. Like with this specific case, can you prove that that Devin Frost knew Willie Freeman was going to kill him? And what he said directly before that would technically be statement under belief of impending death. All right. So 804 section B, statement 3 is statement against interest, which is a statement which was at the time of its making so far contrary to the declarant's personary or proprietary interest, or so far tended to subject the declarant to criminal or civil liability, or to render invalid a claim that a declarant against another, that a reasonable person in the declarant's position would not have made the statement unless believing it to be true. A statement tending to expose the declarant to criminal liability and an offer to exculpate the accused is not admissible unless corroborating circumstances clearly indicate the trustworthy of the statement. Basically, what it is saying is that if your declarant who is unavailable says something that would have them subject to criminal liability or civil or be in trouble with the law, and they believe that that statement is true and would not made that statement if they didn't believe it was true, therefore it is under the exception. Okay, so statement of a personal or family history. So a statement concerning the declarant's own birth, adoption, marriage, divorce, legitimacy, relationship by blood, adoption or marriage, ancestry, or other similar fact of personal or family history. That is what would be considered an exception, or a statement concerning the foregoing matters and death of another person if the declarant was related to, either by blood, adoption, or marriage, was so intimately associated with the other's family as to be likely to have accurate information concerning the matter declared. So sub B is if you have basically it's just like if you have a cousin who's not actually your cousin, but you consider it a cousin, they would be considered under subsection B. And basically, this whole exception is that they state a statement about somebody in their family, about family matters, that would be considered admissible. And subsection 6 is a forfeiture by wrongdoing, a statement offered against a party that is engaged or acquisite in wrongdoing that was intended to and did procure the unavailability of the declarant as a witness. Basically, this could be a statement of a statement that led to the death of the declarant, whether it had something to do with hurting themselves or that they did wrongdoing that was intended to the unavailability of the witness. Does that make sense? Like they did a crime that was intended to cause them to be unavailable in that sense, and if they said something about it. All right. So our last objection, that was a lot. So 803 and 804 all have to do with exceptions to hearsay. And you want to look at them and figure out what exactly is applicable to your case and how to navigate any hearsay objections. But be careful. Every time that you do have an out-of-court statement, be ready with that hearsay exception. Because when you have that exception, you are going to have the objection go to your side. However, if you don't have that exception, you should be prepared for the hearsay objection to be sustained. As it could be, or maybe the judge has a reasoning for itself, but it gets a lot trickier for the objection to be overruled if you do not provide an exception. Last but not least, 805, hearsay within hearsay. Hearsay included within hearsay is not excluded under the hearsay rule if each part of the combined statement confirms, with an exception to the hearsay rule provided in these rules. Hearsay within hearsay is just a very, very long he said, she said, he said, she said, he said, she said, creating to this whole idea of hearsay within hearsay. Causing of that somebody overheard somebody and then that person then overheard somebody else talk and that person is then testifying. Basically, if you think of a rumor mill, you could call that hearsay within hearsay. But leading with that, you're going to find all the objections on the mock trial rule of evidence. And if this video was helpful to you, that is awesome. But if you still have some questions or are still really struggling with understanding these objections, please feel free to reach out to me and I can get back to you as quickly as possible and we can go through these objections once again. But be prepared that all of your judges do understand and know these objections and are going to help you. The biggest thing when it comes to objections is learning how to pivot and how to rephrase your questions, move on, or explain your objections or explain why that objection is wrong, and really just standing up for yourself and having that knowledge of this rules of evidence at your disposal to help win as many decisions as possible. I wish you guys all the best of luck at state conference, and I cannot wait to see you there. Bye.